Thank you, each and every one of you that are here. I'm very, very pleased and honored to be giving this presentation. I call it a workshop, and the reason I call it a workshop is because I'm expecting you to engage. I'm going to give some questions, and hopefully you will get to write some answers, and then we can discuss them. I call this session Demystifying Intellectual Property because when we talk about intellectual property, we get into all this like, what is intellectual property? And maybe that's the first question I would ask you all. When you hear intellectual property, what do you think of?
It's like copyright stuff, copyright, trademark stuff, right?
Yeah, to me it's anything that like adds value or gives you an edge over other companies. We do marketing funnels, we do content funnels. HubSpot and Salesforce own patents for sales funnels and sales automation, but I don't think they'll ever enforce it, but like it exists.
I learned this year that artists, even if they sell their work, still own the intellectual property. So nobody can without the express written, permission from the artist, they can't, recopy or make prints or anything like that. So that's something for people who buy art to know, and I didn't know that either. So really important in my line of work for sure.
That's great. That's exactly what I was looking for. And what Adam said is generally when people talk about intellectual property, they infer trademark, copyright, and technology innovation synonymously with patent, But really, truthfully, intellectual property is anything that your company does that gives you a specific competitive edge. So it could be a database you have created, it could be a contact list, it could be a recipe if you're a restaurant owner. Then you say, well, is a recipe something that can be patented? The answer is no, and there's a reason for it. So now the question then is, should you as a small business owner pursue these protections that government provides you? Yes, there are some legal things you can do to protect yourself. For example, if you wanted to trademark your logo, if you wanted to copyright, you can put down a TM next to your logo name, your trade name, your product name, for example, footlong sandwich, you could put a TM next to it right away. If you did that, you are protecting yourself. Now, if somebody else uses it and calls it a footlong sandwich, would they be infringing on you? Yes, it would be incumbent upon you to pursue it. And that's where the business owners need to recognize that anything that you do legally is only as good as your ability to sue. It does not give you a monopoly. Simply because you registered, you got yourself a patent after spending 2 or 3 years of your life and maybe $30,000 to $40,000 of your money, a patent would generally become a wall hanging. Truly, just to give you a number on the patent, I don't want to dwell on patent as much, but just to give you a number, in the United States, we spend over $1 trillion in research through universities. 90% plus of that simply becomes wall hanging. It goes into the portfolio of a professor that says they got a patent, they never get the technology commercialized through the university. And I'm not taking on the university right now, it's a crusade, but just to illustrate that before you make that step, you take that step, consider whether it's something that's worthwhile for you. Is it something that you will pursue it if somebody were to intrude on it? And you have the power to do it and the resources to do it. So keep that in mind. So all that being said, so 3 things. First, a trademark is a word, a phrase, a symbol, design, or combination that helps consumers identify a particular product. So for example, a footlong sandwich or anything like that. A service mark is similar to a trademark that applies to an organization that provides services. Pullman Marketing could be part of the service. North Star would be a service. Plumber would be a service. Pullman Delivery would be a service as well. So you can actually put in a TM next to Pullman Delivery, and you would get protection that's only limited to as far as you want to go. It's not a legally provided, legally registered trademark, but at least you recognize that it's a trademark for you. So then you say, okay, what happens if somebody comes into your territory and start using Delivery Pullman? Same thing with Pullman Marketing. So that's where it comes into play as far as your ability or your interest in pursuing a legal route to try to prevent them from using it. Same thing with copyright. Second, a copyright is a type of legal protection given to content creators and artists. So that's where Desiree New Business would come in. And a patent is an invention that must be something that can be used, that's new, and that's inventive. And inventive means not just a modification to something that already exists, but it has to be novel and it has to be inventive. In this presentation, what I want to do is I want to go over what constitutes each of these, why a small business should or should not pursue legal protection of these, the process of legal protection, and the resources you may need to pursue protection, given enough time. And by the way, a word of disclaimer, I'm not a lawyer, and what I'm sharing with you is based on my own personal experience, having worked in high technology industry for many years, and knowing people like my father-in-law, who has passed away, that created 2 patents for an attachment to a weed, not a weed whacker, but a rototiller that maintains, when you rototill, instead of intruding on the next whatever, it keeps it within that range.
But that's not considered a modification?
He got a patent for it. And guess what the patent is used for? It's a wall hanging, 2 of them. And this is particularly true in technology companies, technology startups. The first thing they want to do is patent it. You know, they have not commercialized it. They have not created the product. Oh, it's going to add value. Great, go for it. Spend two years of your hard-earned life and resources to go out and get a patent. And in the end, you may or may not get what you're looking for. So what I like to do is to tell you a little story. And this is a purely fictional story of a company that was started in this area and expanded. It's named after somebody that's a dear friend of ours, Tia Maria. So Tia Maria starts a cafeteria, cantina, restaurant, Mexican restaurant in Pullman. 2 years later, she expands to Tri-Cities. 2 more years later, she expands to Yakima. In the meantime, she, of course, has a unique design in her wall, in her restaurants, a unique setup of her furniture and all of that. Menu is designed, and menu has an appeal to it, has a certain flavor to it that's unique. In the second year, and of course, she sets up a website, Facebook, Instagram, and all of that. And she gets by the 6th year, she has about 2,000 followers. That's pretty significant. A lot of hard work has gone into it. In the second year of her existence, she also creates a set of products based on some recipe that her grandmother shared with her, making tortilla chips, unique tortilla chips and salsa. She markets that under the same brand name, same logo, and she goes nationwide through that product line. Now, 2 years into her existence, a competitive company starts with the same name, Tia Maria Cantina and Mexican Restaurant, starts it in central Portland, expands to Portland, the downtown Portland, and then gets to establishing as a restaurant in Vancouver, Washington. And then in her 6th year, she gets a letter from his legal company asking her to cease and desist because she has been using Tia Maria. So my question to you is, what if you were a business advisor, what would you, first of all, identify as things that can be copyrighted, that can be trademarked, that can be patented, if any? So that's an assignment for you. We'll give it, let's say, a minute for you all to write down what you think, and then we'll have a discussion. So the first question was, what are the intellectual property items relating to her business?
Well, first there's the name of her business, then there's her business's logo. You mentioned she had a really unique menu, so she could copyright that as well. I think you can trademark recipes. And then you also said she had a really unique seating arrangement, so she could technically, I think, maybe not copyright. Well, yeah, I think it's copyright as well for that one too.
I think also, if we're talking about before she started, make sure to research whether or not that name exists somewhere else. And then also make sure she maintains records of her history. So including like architects or when she opened it, or how she came about the design of the menu and where the recipe came from. So keeping a history, but also researching beforehand.
Trademarking her name, her services, her menu, copyrighting any images, her art on her products, as well as on, her restaurants. Just covering all of her ideas.
All good. All good. Are there anything, sorry, Sandra?
One of the things I don't understand about trademarks is you can trademark just the name, or if you draw the name in a different way, is that a different trademark?
Very good question. Let me explain to you. A trademark can be applied to a specific class. So Bruce Books, if you did it for a bookstore versus name of a book, might be a different class altogether. So that's one thing. And then when you file the trademark application, you can be very specific. You can say the name alone is trademark. That would not cover the font and how the wiggle is. If you had a specific coloring, you could either include or exclude it. So for example, Coca-Cola has a very specific, if you curve your lettering this way, and then all of that is part of the Coca-Cola trademark. In that particular case, the one trademark that they applied for covers it all. So when you apply, depending on how much work you want to put in, if you want to try to define it clearly on what the logo looks like, as well as the name, you can go do that. Or you can simply trademark your name.
When you do a trademark, is that like worldwide? Does that cover the entire world? Does that cover the state of Washington? I mean, what does that cover you?
Very good question. The answer is it's geographically limited. So you could have a Washington trademark, and you could have a United States trademark, and you could have a trademark that goes across the world. You would have to apply it all separately. The key question, again, I want to emphasize is if you are going to operate your business within a limited geographical boundary, and you don't expect to go nationwide, you don't expect to go worldwide, then going through that exercise of trademark, applying for trademark may not make sense, because there are costs not only in time but also money involved in it.
I have another question.
Yeah.
when she opened her store, did she have any idea she was going to be expanding?
That's a very good question. That's, if you were an advisor working with her at the outset, you would ask her. You would be remiss if you didn't ask her, hey, do you have plans to expand? And if you do, these are things that you can choose to do. You can put in a TM. It'll cover you, but it won't cover you as well as if you actually took that and went through the registration process. So that's the next step up. That's where the expense comes in. The TM doesn't cost you anything. You just put a TM next to it.
Historically, what kind of protection would that actually give her?
It's only as good as her ability to sue. And if she doesn't, she might as well keep the money and do what I'm going to point to Chandler. And maybe Chandler, you can share your story on what went through your business.
I'm Chandler. I own True North Moving Company, previously North Star Moving Company. Thus the name change. So 6 months into doing business, I was sent to cease and desist by a company in California who, after research, has no advertising in Washington or Idaho, has no service in Idaho or Washington, has no trademark in Idaho or Washington, but still sent to cease and desist to my company for name. And so what ended up happening is, I'm 6 months into business. I had, no idea. I was talking to Aziz at the time and went to a lawyer, which is quite expensive. And, especially as a new business owner, it was pretty frustrating. And essentially what ended up happening is, so I owned the website with their name on it. They did not have their full name on their website. And so they tried to trademark Washington and Idaho after they sent me the cease and desist. And so I admittedly just called them on it and just said, this is ridiculous. You can't, enforce somewhere you don't service, which, especially in the moving industry, you can service a state, and that's where it ends. As soon as you go out of state, you have to have a ton of different liabilities and DOT regulations, things like that. It's really hard to be undocumented if you're operating in a state if you're not going legally. And so after going through all that information, looking at the logo was different. The name was similar but not the same. We abbreviated the company to Co instead of full company, and had And Storage LLC on it, which at the time made it different. They tried to force me to give up the website, the name, and clientele as well was something they put on their list. And I essentially told them they could pay me $10,000 for the website, or they can go through legal channels because they had no basis, because they weren't advertising, they weren't in Washington state. So with the previous example, since they moved into the state wherever she was operating, at least in my experience, that absolutely is an infringement. And luckily I had a lot of documentation from the start, from people designing the logo, working through the names, documents of us deciding what the name was, just a ton of documentation that I was basically able to go to them and say, okay, here's what you guys are established in Washington. And so what I've ended up doing is just, I have a pending, if they want to buy the website, which I still own to this day, they're welcome to it. But I did end up changing names just because as a new business owner, I didn't want to deal with that, because I do plan on expanding and have certain things that we're working on trademarks to move towards in the future, and I just didn't want to deal with that. That's essentially kind of what happened. It was a lot of lawyers, a lot of rebranding. I think I ended up paying $5,000 to $7,000 in rebranding because we just finished branding everything, which was a little painful. But fortunately, we had the business backing to be able to continue to fund that. And fortunately be able to work through that. But even, lawyers was about $1,000. I know on their side, they paid a lot of money to even send the cease and desist, and that's what I used against them, is I knew they were financially invested, and I looked up what their cost of suing me was going to be, and that's why I offered the $10,000 for the name and the website, because I was under their cost to sue. Long story short, we now have the new name with no infringements. We have written permission from everyone who has similar names in the industry of moving. I have a business license in Idaho and Washington just because I wanted to be overcovered. And then I have trademark pending for the full name, and then we have a DBA of True North Moving Co. So to me that was worth it because we are going to be expanding. But it is expensive. I mean, patents I think run around $2,000 plus lawyers, which makes it probably triple that.
Any questions for Chandler?
Yeah, if the Interchange Drinks tagline becomes "Move Your Body," are you going to call them?
So in the remaining time that we have, put on your thinking cap and say, okay, I don't want to go down this path of going through the trouble. I don't think I need to do that. So how are you thinking about protecting yourself? What are the avenues available to you? And the answer to that question is trade secret. So if you were to develop a customer list, if you were to develop a certain process, a recipe, what's the one way, not the safest way, maybe, but it could work. Tabasco sauce is one example. Coca-Cola is another example, that they have kept it as trade secret. Only a small handful of people know the final component that goes in there, where the Tabasco is grown, etc., who the vendors are. They keep it a secret and trade secret. So then the question is, how are you going to implement a trade secret program within your company? So we covered trademark, we touched on copyright, and we touched on patent. Now I'm throwing a whole new kimono. How do you use the trade secret process? Trade secret, the answer to that is only as good as how you're willing to implement it and how faithful the people are. You can have them sign a non-disclosure agreement. Now when they leave, are they going to stop using things? It's quite natural for people to use certain templates and tools that they learn in one place to another place. And that's one of the main reasons companies would hire experienced people, because you might be bringing some new process, new way of doing things. So it's quite common, and I don't think a company could easily protect those kind of things, tools and templates. But certainly, if you were in sales and marketing, maybe a contact list, a customer list, databases, things that you do, you would want to protect it. You would want to have a good, secure server to have those information, data in it, because now every day you hear of Chinese companies looking at your stuff and, coming in and looking at breaking your systems, etc. So that would be a way that you would want to protect. Anyone want to take it on as far as, would you want to have a trade secret program? Pullman Marketing, I ask Adam. Any need for it?
A little bit.
Interesting.
This year especially, I've had 3 clients, half joking, half serious, wanting to poach my employees. Actually, specifically Preston. He runs a lot of our PPC. And we do have a methodology for how we operate, how we implement. Of course, we're Google certified. Of course, we do everything by the books, but there's, over time and learning, you learn how to bend the algorithm in your favor. And that, for us, that is trade secret. Like we make a lot of video content for small business owners, like, hey, here's some things you should consider, here's things you should do. But we're not saying like, yeah, here's step by step how to mimic our process. So when we even had another client just in the last 2 weeks say, hey, can you send Preston to train my staff to do his job for us, so we don't have to pay you. And so we do actually have those types of systems and processes that I'm a pretty transparent person, but on some of those things I'm pretty careful. But then this year in our contract, we've added, I've had to add clauses saying, you cannot poach my people without written and express permission. Like maybe there is going to be a good fit down the line of like, an employee might be moving to one of our national clients' locations, Oh, okay, yeah, that actually kind of makes sense. Like, let's see if we can help negotiate and make that transition. Because I do care about your business if that works, and sure. But there's penalties or other issues that I put in my contract to say, please don't take my people or approach them.
One thing I might suggest for you is employee training, to repeatedly say, hey, these are things that we, Pullman Marketing, considers to be a trade secret, and we want you to honor it.
So what happened to Tia Maria?
Sorry?
Oh yeah, what happened to Tia Maria?
Oh, Tia Maria, I haven't finished my story. Thank you for asking. By the way, I did mention that it was a fictional story, right? Oh boy, I didn't think of the ending.
And then she found a pro bono lawyer and lived happily ever after.
I love it. I love it.
I mean, if she had thought about, even if she didn't have a trademark, if she could show her steps like you did, there's a possibility that she might be able to, get herself out of it.
Yeah.
Well, and if they're coming from Portland too, like there's that issue of expanding out of Oregon into the state of Washington, where it already has been a set thing.
Right.
Well, that's what I'm trying to tease apart in my mind, why even go through the paperwork if you have that historical basis.
Even given whatever protection that you may have established, a smart lawyer with lots of money can penetrate that. Sorry. I'm glad there's no lawyer here. I'm assuming there's no lawyer. I'm not bad-mouthing them. I'm just saying that's the way it works. The system works. And by the way, our economic system encourages imitations, encourages, and it tries not to get in the way of, because competition and copying actually makes things better. You make yourself more distinctive. So that's the way the economy works. So happy copying.
One thing I might also throw out there too is if you ever look at manufacturing, manufacturing overseas is really quite dangerous because our trademarks and our copyrights don't exist, they don't work. And even if you do a registration in Indonesia or China or other manufacturing countries, it doesn't mean they don't have a subsidiary in the other country. And it's very common practice in the music world. I see this a lot actually, on the ukuleles. We do have patented designs for ukuleles, but when it's sent over to Indonesia, they'll actually say, great, we now have how you build it, and then they'll find another company to sell it to at that discounted price. And they may alter one or two things just to lower the price and make it cheaper, but that has been a consistent issue in that industry in terms of music, but then also specifically stringed instruments have that a lot.
Great input. Thank you so much. I see GPI. Maybe GPI, you have been very quiet. So tell me about GPI and what issues or anything that...
Our biggest, well, we're over it now because it's been 5 years, but we split from another company. I was talking to Adam about this earlier. We used to be Strata, which is a nationwide geotechnical firm, and we had some local engineers that split from Strata to form GPI. So we had a lot of issues with the client base being trade secret because our clients get very loyal to the engineers. The engineers know the most about the project. They don't necessarily want to switch to a different Strata office with different engineers who don't know Pullman or Moscow. You all know this, but the Palouse has a very, very specific geotechnical makeup. And getting an engineer out of even Spokane, they're not going to know what happens here. So we had a lot of issues with clients and continuing projects, having to change contracts over from Strata to GPI, breaking Strata contracts with other clients, re-signing new ones.
I hope I have given you some food for thought. I have a presentation that I'm happy to share. I'll send it to you, and if anybody wants, and you have the people that are attending, you're welcome to share that. And in my presentation, there are resources and links if you want to learn more. There are videos, etc., links to videos, etc. Some of it is amazing. You will learn a lot. but I urge you not to go down the lawyer path because it will take you 4 years of your life. Yeah. So thank you all.